Welcome to our comprehensive video about the 601a Waiver. The information we will provide is aimed at giving you a better understanding, but please remember that it is not a substitute for professional legal advice. In this video, we will cover the definition and purpose of the 601a Waiver, the eligibility requirements, the required documentation, conditions under which expedited processing can be requested, how to go about requesting it, potential outcomes of the request, and some important legal considerations. A 601a Waiver is primarily used by individuals who are unlawfully present in the U.S. to apply for a provisional waiver of the unlawful presence grounds of inadmissibility under Section 212a 9b of the Immigration and Nationality Act. Now let's cover the eligibility criteria. The applicant must be physically present in the United States at the time of filing the application. They should be at least 17 years old and have either an approved I-130 or I-360 petition, or be selected for a diversity visa. The qualifying relative, who could be a spouse or parent, must be a U.S. citizen or a lawful permanent resident. It's important to provide evidence showing extreme hardship to these qualifying relatives if the waiver is not granted. For a complete 601a Waiver application, several documents are necessary. You will need to prepare Form I-601a, along with a copy of the Form I-130 or I-360 approval notice, proof of your relationship with the qualifying relative, as well as proof of their U.S. citizenship or lawful permanent resident status, will be required. Additionally, you must provide evidence of the extreme hardship the qualifying relative would experience if your waiver is not approved. Expedited processing may be granted under specific conditions, often related to cases of extreme hardship or urgent medical conditions. However, the health of the petitioner or qualifying relative can be considered, but isn't a guarantee for expedited processing. To get expedited processing, the applicant should clearly lay out extraordinary circumstances that require urgency. To request expedited processing, start by identifying the reasons that support your need for urgency, such as extreme hardship or other urgent conditions. Next, gather all the necessary documents that substantiate these claims. When filing your standard 601a Waiver application, you will need to submit your request for expedited processing using the proper forms. Ensure to follow the detailed submission guidelines as provided by the relevant jurisdiction. Let's test your knowledge with a quick quiz. What is a key requirement to qualify for a 601a Waiver? Is it that the applicant must be under 17 years old? That they must be physically present in the U.S.? That they must be outside the U.S. when applying? Or that the applicant's health is a factor? You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is that the applicant must be physically present in the U.S. when filing the 601a Waiver. This is indeed one of the critical eligibility requirements for this process. When a request for expedited processing is made, if it's granted, this can significantly expedite the timeline for both review and decision of the waiver application. If the expedited processing is denied, the application will continue through the regular processing timelines. Should a request be denied, applicants are advised to revisit their supporting documents and reasonings and consider whether additional information could be included to strengthen their case. Some critical legal considerations include consulting with an immigration attorney, which is highly recommended. Each case is unique, with its own specific circumstances requiring detailed documentation. Never assume eligibility for expedited processing without substantiated reasons to ensure compliance and proper submission. To wrap up, understanding what a 601a Waiver entails is essential. Ensuring eligibility and having the correct documentation in place are vital steps in the process. Remember that expedited processing is an exception and not a rule, requiring specific qualifying circumstances. Ultimately, seeking legal guidance remains crucial for properly navigating complex immigration matters. Thank you all for watching this video. We hope you found the content informative and helpful. If you enjoyed it, please feel free to like the video, share it with friends, and be sure to subscribe to our channel. Let us know your thoughts in the comments below.